Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Welcome to the Mineral Rights Podcast. I'm your host, Matt Sands, and I'm here to help you make the most of your minerals and royalties. This week, Justin Williams and I speak with Liana Jones, an attorney with Lear & Lear PLLC, to help us understand the ins and outs of title opinions. We discuss everything you ever wanted to know about title opinions, including the role of the title attorney, why operators need title opinions, the type of title opinions that are relevant to oil and gas, why royalty interests are sometimes put in suspense by an operator, and why this is not necessarily a bad thing. And we also talk about some issues that can come up with title opinions and what you need to know as a mineral interest or royalty owner. This was a really interesting conversation, and I have to say I really learned a lot. And I knew, of course, a little bit about title opinions before, but thanks to Liana's easy to understand explanations, I feel like she really expanded my depth of knowledge in the subject. And so I hope the same will be true for you. Ms. Jones' background is in natural resource law and transactional practice with an emphasis on oil and gas title. Her primary interest pertains to public lands and complex title issues. In her spare time, she enjoys outdoor recreational activities to include backpacking, cycling, skiing, and snowboarding. And her practice includes natural resources and public lands law with emphasis on mineral law, oil and gas law and litigation, complex title examinations, administrative hearings and appeals, public land law, and timber and logging law. But before we get started, I have a quick reminder. The links that we mentioned can be found in the show notes for this episode at mineralrightspodcast.com, as always. And also be sure to subscribe and leave a rating and review on iTunes or wherever you get your podcasts. It really helps us reach everybody that needs to hear this information, and we greatly appreciate it. So without further ado, here is Liana Jones with the energy law firm Lear & Lear. Welcome, Liana, to the Mineral Rights Podcast. Thanks so much for joining us. How are you doing today?
I'm doing great. Thanks for having me. I'm really excited to chat a little bit about title opinions. I know nobody's ever said that before, but hopefully it's interesting for everybody. And thanks to you and Justin for having me.
Absolutely. Well, let's just go ahead and dive in with our first question around a little bit of background. So can you tell us a little bit about how you got started in oil and gas and mineral rights?
Sure. Yeah. So I went to law school at the University of Utah. They have a really great natural resource program there. And I was interested in that program, learned a little bit more about oil and gas. And one of my now coworkers connected me with a law firm and one of the really well respected title attorneys, maybe one of the better respected title attorneys in the country. And I was able to clerk for him for about a year. And that kind of just got me started down that road. The thing I really like about title is that it's a little bit like a puzzle, and I like the history of it. So I think it's pretty fun, and I've been in the field now for going on 11 years.
Very cool. And you're licensed to practice in Colorado, is that right?
Yeah, as well as Utah. So the firm that I work for, Lear & Lear, we are actually headquartered in Salt Lake City. We have an office there. And then we're licensed to practice in a little over 20 states. We're constantly getting new licenses as plays come online, but we can render title opinions in a little over 20 states.
Okay. So pretty much wherever there's oil and gas, you guys have attorney that's licensed in that state and have worked there more than likely, it sounds like.
Yeah, exactly.
Cool. So you mentioned that, your excitement around title opinions, and what are some of the things related to the law you're most interested in right now or researching?
Oh gosh. Right now I think especially what's going on in the world with COVID-19 and with plummeting oil prices, we're going to really start to see a lot of interesting applications of lease clauses, force majeure clauses, shut-in clauses. A couple of years ago, I did a little bit of research on shut-in clauses and the effect of gas-only shut-in clauses. And we really only saw that come into play back in the 80s, and we may see that again. So I think that's going to be really interesting as we come out of this, and if there is any litigation that develops from the application of lease clauses. That's going to be really interesting. And then, I think you guys spoke at some point on the show about this, but I've been really interested in the takings clauses and what's the effect of takings on real property and on minerals when you're dealing with a situation of maybe government legislation or regulation that prevents mineral interest owners from using their mineral rights, and what kind of recourses they have there. So that's something I've sort of been not necessarily researching, but thinking about recently.
Yeah, that's something definitely is applicable in Colorado with SB 19181. I know that depending on how that actually gets implemented, I know there's sort of a in limbo right now with the rule, some of the rulemakings and some of the local jurisdictions. I could see there being some upset mineral owners if they decide to limit development of certain acreage. Hopefully, once prices get better and activity resumes. So I can see that being a hot area for sure. So let's talk a little bit about title opinions. You mentioned that as kind of your area of expertise. So just for our listeners who may not be familiar, what is a title opinion?
Sure. So, yeah, predominantly what I do is I prepare title opinions. They come in a number of different forms, which I'll get to, but they're basically title insurance policies that allow operators to know that one, they have the right to drill on a parcel and any issues that are disclosed in the title that need to be cleared up before drilling. And then two, who to pay proceeds to and what issues need to be cleared up before paying all those parties. And the why sort of goes hand in hand. The operators really can't drill on a piece of property without knowing that one, they have the right to do so, and two, they need to know who owns the minerals and who to pay, because a failure to do so could result in trespass claims, maybe negligence claims, but definitely trespass. So, it's part of their due diligence process before they actually drill a well, and we tell them who owns everything and whether or not they've got the green light to go ahead and drill on that parcel.
Yeah, I know that when I was at Shell and we were working in the Marcellus, and right when we were getting started, it was an issue with trying to make sure we had title opinion and we had clear title before the rig could move on site, just to exactly what you said, to prevent that trespass scenario, which was certainly every operator, I imagine, wants to avoid that because of the liability that would bring. But so tell me a little bit about title opinion process and what's the typical process that operators follow?
Sure. So, there's always, of course, like the internal planning that goes on within the operators. And I have pretty limited knowledge of that. That's internal, it's proprietary. It's deciding where they want to drill, targeting formations, doing geology and seismic and stuff. So, once they've determined where they're going to drill, operators will usually have a rig schedule planned. I know that they like to have it planned pretty far in advance, but it can change, as we can see right now. So that, they have their internal planning process. And once they've decided which parcels they're going to drill on, they'll usually contact a land company and request an abstract. The abstract is generally includes your run sheet, all of your title documents that have been recorded against that particular piece of property, tax information. If necessary, they may have gone to various other courthouses to obtain probate records. But basically, they've put together every document related to that tract of land, and they've put it together kind of succinctly for us. And then they request a title opinion from a firm such as ours. And at that point, we review the title, every single document that's been recorded against that piece of property, and we put together ownership schedules. We show who owns the surface, depending on the type of opinion, but the surface, the minerals, if there's any, non-participating interests, it'll show that. We show overrides and working interest as well. So it's a big package of numbers there. And then we also have our comments and requirements, and that's basically discussing any title issues that were disclosed in our examination and how to fix them. And then we usually have a leasehold and assignment analysis as well.
Okay, so you mentioned kind of the process. Now, I've heard of a couple of different types of title opinions. Can you talk about what are the types that are relevant to oil and gas specifically?
Sure, yeah, of course. And your listeners, they may have seen some title opinions. They may have seen a comment that applies to their interest specifically, but I was going to talk about four types of opinions that really most operators will get. The first one is your drilling title opinion, and that's that first step, like you were talking about in the Marcellus there. That is, do we have the right to drill on this property? Who owns the surface? And who owns the minerals so that we can go out and lease them? They may already be leased, but at least they're going to see, all right, who do we need to get leases from? Who do we pay bonuses to? The percentages of ownership there. The next step is the division order title opinion. So once we've issued the drilling title opinion, that basically gives the green light to, move the rig onto that property. Then before you pay proceeds, you need to know how much you're going to pay each party. So the division order title opinion gets a little more specific into the lease analysis and the net revenue interest that's attributable to each owner. So the division order title opinion provides an ownership schedule with a net revenue interest and also the comments and requirements related to the division order opinion. Those address who to pay and if there's any defects disclosed in who is entitled to proceeds. Those are addressed in your division order title opinion. Sometimes we can combine those, and we call those drilling and division order title opinions. And then the last category is an acquisition opinion. So I write acquisition opinions for mineral acquisition companies. So, companies that are going out and buying mineral interests. Sometimes they'll get title opinions just to make sure that the parties that they're purchasing from have clear title. But also, we'll do acquisition opinions for some of our operators as well. If they're buying a lease play from another operator in a specific area, we will go in and do a title review of the assets being purchased. And that can include, full mineral title as well as full leasehold title for them as well. So, and they're kind of the four big ones that I do on a day-to-day basis.
Got it. And now, with the drilling title opinion and then the division order title opinion, is it also like a timing issue where, like you said earlier, the drilling title opinion is done before they even bring the rig on site? And then after they've drilled the wells and they are completing the wells and they're going to have the division order title opinion so that, like you said, they can confirm the ownership and make sure that they understand who they're going to have to pay. Now, is it something where you go back and, in between that drilling title opinion and the division order title opinion, do you go and do another search of courthouse documents to see if there's been any conveyances or anything like that? Can you talk about the difference there?
Sure, yeah. And they're not always separate. I guess I'll start that way. A lot of operators are choosing to do a combined drilling and division order opinion these days. It can save costs a little bit. But yeah, usually if there's any kind of gap in timing between your drilling title opinion and your division order opinion, it's definitely best practice to get your abstract updated. So go back to the clerk and recorder's office, make sure there was nothing else recorded that could affect title. And it's always best to get them updated. It's obviously cost determinative and operator preference, but generally speaking, yeah, we usually do see them get updated and we try to bring title as current as possible for the operators.
Okay, thanks. So, we talk about division order title opinion. The role that comes to mind is a division order analyst. And I know a lot of our listeners have spoken with division order analysts or gotten letters from them, maybe when they received a division order. So they understand kind of there's that person at the operator that does something. Now, what's your interaction with a division order analyst like as the title attorney? What kind of information are you conveying to them, and sort of can you talk about how that person fits into the picture?
Sure, yeah. So the title opinions are generally ordered by an in-house landman with the operator. And by and large, I would say the communication between the title attorney and the operator usually goes through the landman that ordered the title opinion. The division order analyst, I'd say our biggest goal is to not frustrate them. They're the ones that take the opinions and they're the ones that put it into the operator's internal pay decks. And each operator has their own spreadsheets and ways of organizing their pay decks. But when they get our opinion, those are the numbers that they are putting into their software to pay people. So I love knowing division orders preferences. I love having the ability to, kind of tailor it for each operator so that their division order team can take the material, put it into their software, and be able to pay people. The landmen themselves are the ones that usually go out and cure the comments and requirements that are set forth in the opinion. So after we send the opinions to the operators, they go through each comment and requirement, and they will obtain curative, or in some cases they might waive it. But they'll go through line item by line item to make sure that everything has been satisfied so that we're paying the right parties. And then anything that they cure, they'll go to the division order analysts and, inform them that, hey, we can pay on this, or no, this one is still in suspense. Every once in a while, I'll get a question from a division order analyst about whether or not a particular party can be taken out of suspense if they've provided X, Y, and Z. But for the most part, my interaction with, in terms of with the operators, is with the landman that's ordered the opinion.
Okay, thanks. I thought that it was more of a direct line of sight, but that helps me understand because, like you said, it makes sense that the landman is going after you've prepared the title opinion and then taking that information to follow up with landowners and see if there's additional documentation to cure title and whatever it needs to get done from the operator standpoint. And is it a scenario where if you identify a title defect, is it something that it's generally up to the operator to determine how to cure that, or is it like, pretty much you have to have, in order to have marketable title, then that's how you get paid, and here's what you need to do to get marketable title? Can you talk a little bit about that?
Yeah, sure, of course. Kind of a multi-part answer, I guess, but our requirements will set out the legal steps necessary to obtain marketable title, in states that have marketable title acts, and or what needs to be done to satisfy your title attorney, essentially. Every operator has a different level of risk tolerance. And also, a lot of it really does depend on the size of the interest, the scope of the curative. If really the only way to cure something is to get a quiet title action and it's a very small interest, certain operators may elect to waive that requirement, or, try to find another alternative to get it pretty close, but maybe not quite to the high standard that their title attorney is asking for. Sometimes we can lay out multiple options. If, say, best case scenario, you get a quiet title action and you can record that judgment. Next case scenario, maybe quick claim deeds can cure something. We'll try to provide some different options there, but the title attorney's job, by and large, is to provide the highest standard to obtain clear title. And whether or not the operator decides that, yeah, that's what the step they're going to take in order to cure that defect and to take those parties out of suspense, that is an internal decision. Usually, sometimes they'll come back to us and say, okay, hey, we may not do a quiet title here. What else could we do? And we'll begrudgingly try to give them some other options. But the title attorneys, our risk tolerance is very low, and we try to get everything as close as we can to complying with case law, with statutes, and having really clear title. So we set our standards quite high. Operators can choose to stick just to what's in their opinion. Sometimes they can waive things. That's kind of an internal thing for them to do.
That makes a lot of sense, and I'm sure that it varies greatly amongst the operators on what they choose to do. So going a little bit more granular on title defects and curative measures, in previous episodes we've mentioned a interest being placed in pay status or being placed in suspense by the operator. From your end, what are some of the more common reasons that you see that the title attorney may recommend to put an interest in suspense?
Sure. So we recommend suspension if there's a risk of paying the wrong party, or if there's a risk of paying parties in the wrong amounts. that's really when we elect to suspend an interest. Most states have statutory or regulatory guidelines that say when an interest can be suspended. I'd say most commonly we'll suspend for missing probates and even incomplete probates. We'll sometimes put things in suspense because the longer you do title, you understand that nothing is ever quite as clear as you would like it to be. So, we might have a will that says X, Y, and Z, and then a deed comes down later that turns out we gave it all to some brother that was not even mentioned in the will. So, the title attorneys are prepared for every worst case scenario. Suspension is the tool that can protect the operator from paying the wrong people. And so, yeah, commonly I'll suspend for probates, missing probates, or incomplete probates. If there's a lawsuit pending, that's definitely something that's going to get suspended pending the outcome of that. And then document interpretation, which I think we're maybe going to talk about later, but an instrument that could create a question as to how much was conveyed or how much was reserved. If there's any kind of conflict or competing claims, that's when suspension will come up as well.
Sure. And, is having your interest placed in suspense, is it necessarily a bad thing?
No, not necessarily. Oftentimes your suspended interest can be cleared up pretty easily. Like I said, the biggest reason is for probate reasons, and those can get cleared up pretty easily and pretty quickly at this point. And usually it'll come down the way that everybody's expecting it to, and that's terrific. And the other reason why it's not a bad thing is if the operator is kind of freezing things and they're protecting the mineral interest owner as well from potentially a conflict with other mineral interest owners by making sure that the correct owner is determined and that the correct parties are being paid so that there's not claims of action against the people that they're paying. It's just like a safety net for everybody there. And then, one other thing you could think about is if you're considering selling your minerals, you will want to have clear title to those minerals as well. So your acquisition company is going to ask for clear title, and they're going to, do an acquisition title opinion. And so they could see the things that your interest would be held in suspense for. So if you're considering selling, getting these things cleared up in advance will make your selling process a lot easier as well.
Sure. And I think it would be fair to say that it's a lot easier to handle these by putting them in suspense and trying to clear it up rather than, like you mentioned, making a case against maybe other mineral owners in the chain or something else.
Sure. I mean, the last thing that anybody wants is for the wrong parties to be paid and then trying to sort it out after the fact. That's going to cause a lot more conflict than just putting a little bit of a pause on things, clearing it up, and then paying forward from there.
Absolutely, that makes sense. And kind of the $1 million question here, I think that a lot of mineral right owners have. How is it that operator A can make one determination on the same chain of title, but operator B makes a totally different determination on the title? And this is something that I think is pretty common and usually can be rectified. But how does that happen?
Sure. Yeah, this is a good one, and it can be a number of factors. We can, as I mentioned, there's risk tolerance within operators themselves. So maybe certain operators are willing to pay on interests when others are not. There can also be document interpretation discrepancies. And so, I think this is where I've seen it the most when we have really clear differences from, one operator to another or one parcel to another that have common ownership. There could be a really tricky deed in there that required a call. And, title attorneys are human. And I think we're going to get to sort of the process of making calls on instruments. But title attorney A could reach one determination, and it could very well be founded on case law. And title attorney B could make another call that could also be supported by case law. And there may not be a quote unquote right answer until a court has adjudicated that particular issue. So that's I think the biggest thing that I've seen. And then of course, you can also get into, incomplete title records. Utah, for example, they've had issues with documents getting lost or destroyed, or, just maybe not as complete abstracts being built. A title attorney is only able to review what they have. So if a document was missed in the abstracting portion, that could change the whole ownership. That's definitely happened. And then of course, mistakes happen as well. So it's really important to be mindful of all of those factors and to stay vigilant and ask questions about, hey, why is this different in one section and another? Because, it could be that you're entitled to a greater interest. It could be that a mistake was made. And it could be that, again, just your operators have different levels of risk tolerance. So there's a number of reasons there. And so I can understand why it's really frustrating for mineral interest owners when they may have, two sections of land and two operators are paying and their NRIs are different. That's definitely something to question. And it can happen though.
Absolutely. And I think it goes back to something you said before, and that's that though the intent always is to try to be as clear as possible, things just aren't always as clear as we would like them to be. And kind of on this topic, so what should a mineral owner or royalty owner do if they think that the net revenue interest shown on the division order is wrong? What is the first step? Kind of where do they go?
Sure. So I think the first step is to contact your division order analyst, the one that you work with the most at a particular company. I understand that this can be somewhat challenging. You may not get far, but if there are any title requirements related to your interest that might be affecting your NRI, I would certainly try to get a hold of those. So sometimes operators will send just the comment and requirement that's related to a certain interest. They'll send those out to parties. I would start there and see if, maybe there was a document interpretation issue that you can read through, you can educate yourself about, and then, take steps from there. If your division order analyst isn't able to help you, at that point, I would recommend contacting a qualified landman or a title attorney and just run your title. If you have a significant amount of minerals, it's worth knowing what you own, how much you own, the defects that might be in your chain of title. And so then you can come to the table with knowledge and with preparation of, this is what my chain of title looks like. These are the places where it could vary, but hey, I've run title and this is what my NRI should be. That's going to be the thing that you're going to need in order to really get your interest changed or to go to the operator. You're going to have, a complete picture of your title. So start with your division order analyst, then maybe work to a landman or a title attorney and actually run out your title.
Absolutely. We've talked many times before that generally people just really want to help. And sometimes, like you mentioned, it's not necessarily known that there's a mistake being made or that they don't want to fix it. Maybe just that a person in the past made that mistake and they didn't realize it. So it's always good to contact, but having that attorney is important.
Yeah, definitely. And from my perspective, if a mineral interest owner does approach the operator claiming a different interest and the operator has reason to believe that this person is entitled to a different amount, the operator will come to the title attorney that prepared the opinion. And if that happens to me, I stop what I'm doing and dive into this because, if I made a mistake, 100% I need to rectify that and make sure that everybody's getting paid in the correct amount. Or, if there's not a mistake, it's really important for all the parties to know why we called title the way we did. And so, sometimes we'll actually go back and review the chain or even rechain the interest in question and then, provide all of that to the operator with a detailed response. We'll include documents if necessary, just so that then, the operator can engage in the conversation with the mineral interest owners and say, this is why the title attorney called title as X. We see you have it as Y. Here are the documents that they think could be problematic. And if the mineral interest owner has gone to a title attorney as well, maybe they've got the same documents and much like what we were discussing about how different operators can have, different NRIs in common ownership sections, two title attorneys could land on different sides of a document interpretation situation. And at that point, at least both parties the operator has the information that they need and what their title attorney said, and the mineral interest owner will have what they said, and, the parties can go from there.
Yeah, and I think that that's a good point that you bring up, that it's a two-way street, right? So it's a conversation that definitely having a qualified attorney on your side is worth their weight in gold when it comes to complex legal decisions and conflicts like this. So, that's definitely important to have somebody on your side to help out. And can you talk a little bit about one of the issues that has been a hot topic over the past few years is post-production deductions and interpretation of leases. And so, on the subject of interpretation and, going one way versus the other, how conservative or aggressive have you seen operators in interpreting leases? And is that the same sort of judgment call that you've seen?
This was an interesting question, and I actually asked a couple of my colleagues if they had more direct examples of this. And really, we couldn't speak to conservative versus aggressive, but in light of litigation that's occurred, like you just mentioned, within the past like decade or so, as well as statutory changes that define what operators may deduct. I know that many companies are moving away from company-wide deductions, so sort of blanket deductions without reviewing lease language, and they are really carefully paying attention to lease terms. But that's not to say, of course, that lease deductions don't vary by company and by operator. Oftentimes, there will be unrecorded contracts that can affect your deductions. There's, transportation contracts or gathering contracts or something of that nature that could adjust prices as well, that the title attorneys really don't have privy to. But at this point, I would say within the past 5 or 6 years, most of our operators are coming to us with the request that specific lease language regarding post-production expenses is put into the lease analysis section of the title opinion, and to flag unusual or highly restrictive language. So to us, that's really shown that they're trying to shore up their deductions and pay on what's allowed by the lease. Again, conservative versus aggressive is a little hard to answer. I do think in light of litigation, companies are trying their best to stick within the letter of the law and what's written in the leases.
Got it. So it's really tied to the specific wording of the lease. Is that kind of the gist?
It is, yes, of course, then the more modern savvy leases are trying to really define what can be deducted and what cannot. It's the older leases with boilerplate language where I think you can see larger variations in what's being deducted and what isn't. And then, of course, that's really kind of operator proprietary there. And we're also often asked this question by some of our mineral interest owners. Hey, why is company X paying us on this well and deducting this amount when company B is paying us and deducting this amount on a well in the same section? Why is that? And a lot of times the title attorneys, we just don't have access to that information. So we're doing our best to guess as well, and we're hoping that they're paying within the lease terms, but unfortunately it's not something that we see as often on the title side.
Interesting. Okay, so I know, Justin, you've run into this before, haven't you? In terms of maybe the same lease, but operators are deducting different amounts. It's been interpreted a couple different ways.
That's correct. And I think it makes a lot of sense to what you said in that it could be contracts with the gatherer or the transportation or something that we're not seeing. And I think that makes a lot of sense.
Sure, and I think right now is a really great time to, go ahead and audit your deductions. Just familiarize yourself with that. Take a look at it. If you start seeing your proceeds decrease as the value of oil is decreasing, it's really important to take a look at that. Make sure you think everything is fair. If you're being paid by different operators on the same lease, it is valuable to try to figure out if it's still within this blanket of reasonableness and communicate with your operator about, hey, what are these expenses? What are you deducting? That they usually don't like to provide us with contracts, but they will try to provide answers for you too. So, if you have a question about your deductions, again, start with your division order analyst and see if you can get some answers from them.
Absolutely. Something else I've had personal experience with is how often do operators update their title opinions? And I guess let me add to that question saying, is it just the nature of oil and gas being such a long life cycle that maybe the title opinions aren't the freshest thing in the world? Or do sometimes operators use benchmark title opinions and just kind of run title forward for certain wells? Or maybe you can enlighten us on that.
Sure. I think, again, that really just varies by situation and by operator risk tolerance. I know I've probably said that 100 times already, but each company has their own level of what they're willing to spend in order to have everything really shored up, or if they think it's something that they can continue to handle in-house. If it's a well that's been drilled and there's 2 leases and maybe 5 mineral interest owners on that property, that might not get updated for quite some time. And, division order analysts are updating their pay decks as they receive new information from mineral interest owners. So if an acquisition company purchases an interest, they'll mail the deed in and the decks will get updated. Or if a working interest owner sells their interest, they'll notify the operator of that sale and things will get updated that way. Usually the title opinions are updated if there's a big expenditure of capital. So if you're seeing new wells be drilled, infill wells be drilled, if we are getting a new drilling unit, oftentimes we'll prepare a new opinion for that. Or if maybe the unit encompasses 2 sections, and so there was an original opinion for each of those sections that are now being pooled in one unit, we'll prepare a title opinion covering the 2 sections. And so that'll be a supplement to those 2 original opinions. And sometimes operators will just supplement particularly challenging opinions if they've got, hundreds of mineral interest owners. It's always a best practice to update and make sure that the interests are being tabulated properly and that all of the conveyances are being caught and updated that way. Because with those larger sections, sometimes deeds can be missed or not sent in or something like that. So, but there's really no timeline or formula to when a title opinion is supplemented or updated.
Sure. Again, just up to the operators, and I'm sure it varies greatly. Another interesting question here. So, with title defects and things like that, let's talk about the burden of proof. Is it on the operator or is it on the mineral owner to prove title?
It is the operator's duty to run title and to obtain the title opinion. So, in that sense, it is the operator's responsibility to figure out who owns in the particular section that they want to drill on. However, I think practically speaking, once a title opinion has been rendered, I think that the burden to change any ownership would fall more or less on the mineral interest owner. So, of course, we've seen the lease forms that contain language about the time period in which the operator has to pay a new owner in the event of an assignment. That's sort of incumbent on the mineral interest owner to provide the operator with a deed or a conveyance or something reflecting new ownership. So that shows that the mineral interest owner has that responsibility to notify the operator of a change in ownership. And at the same time, if the mineral interest owner believes that their opinion differs from what the operator is paying, and what the operator is paying is based on what the title opinion has said, it is somewhat upon the mineral interest owner to bring that evidence to the operator and work to have, either the interest corrected if it was incorrect, or if they believe it was changed, it's really upon the mineral interest owner to provide evidence of that. So if there's a genuine conflict, I don't often see operators being willing to change what they have, without either deeds or court orders.
Sure. And I think it's such a multifaceted and complex question, truly, and so situational depending on your circumstances.
Yeah, and it's a lot of back and forth. and, kind of the process that we talked through earlier of both sides kind of working through why a particular decision was made. And I've definitely been in the position where we've worked through something and the parties involved have elected to change how I called an interest. And, because often there are situations where it really just isn't clear. And at some point, we have to issue the opinion and we have to make a call because our numbers have to add up to one. And so we'll do the best we can to analyze applicable cases out there and make a decision on how we call a particular interest. But that's not to say that, something in that situation can't get changed.
Sure. And so let's talk a little bit about how it can vary state from state. For example, in my great home state of Texas, I've been told many times, and maybe it's just my circumstances, but that Texas can be particularly challenging, given the long history of oil and gas in the state, the amount of case law that there is, and just how complex titles can get. Is Texas an area where you see more complicated titles or you see more questions come up? Or is this pretty common throughout most of mineral?
Sure. Well, let me go ahead and say I am not licensed in Texas. Our firm is licensed in Texas, and I have rendered opinions in Texas in conjunction with other attorneys in our firm who are licensed in Texas, but I am not licensed there as of yet. So I need to be a little bit careful here on whether or not I'm actually speaking to giving, holding myself out to practice in Texas. But yeah, like you mentioned, Texas has such a rich history of oil and gas development that it also has a rich history of oil and gas litigation. And for that reason, Texas is really valuable. I often joke with people that if you are interested in a particular word in any oil and gas situation in Texas, there's probably a case about it. And that can be challenging, but it can also be helpful. Texas does have because they have so much case law, it's helpful in determining these gray areas, I guess. And that's not to say that every issue in Texas has been decided, but a lot of it has, and it's quite useful. Actually, I find states without quite the breadth of case law to be a little bit more challenging, and I think that's where we can see perhaps more of these discrepancies arise. So Colorado, for example, really doesn't have a lot of case law in the oil and gas area. And so, for example, if we have a situation present itself in Colorado and there's no applicable case law, we do have to look to other states. We can try to find something maybe in a neighboring jurisdiction, or we can try to find something in a jurisdiction that Colorado will often rely on in deciding their own cases. But to some extent, we kind of have to make a judgment call. And so that's a bit what I was talking about in terms of, why we can see things vary from operator to operator or title opinion to title opinion. If I have to review a document, maybe it's ambiguous and I have to make a call, I'm going to then turn to my own state. So if we're in Colorado, I'm going to look to see if Colorado has any laws, if the Colorado Supreme Court has decided that issue, or if the circuit court has, or if there's anything that I can use in Colorado. If not, then I need to look beyond Colorado and start looking in other states. And oftentimes I'll go to Texas. I'll find Texas case law that I'm going to use in support of how I'm going to call an interest. So Texas is actually quite useful for that. And, of course, whether or not a Colorado court is going to apply Texas law to decide something is anybody's guess. So, I think it goes both ways. The title in states with rich history like Texas, it can be a little more challenging because you'll see scenarios present themselves that just given the long duration of production on a piece of property, for example, you could see significantly more owners or significantly more issues as a result of it versus, states with newer production that may not have the parties, selling or conveying or leasing or anything quite to the same extent as in longer producing states like Texas. But sometimes I find that the newer producing states or the states with not as much history, the lack of case law is also quite challenging.
Sure, and I think that's a wonderful perspective that maybe mineral right owners wouldn't even really consider. What are some of the challenges your firm has seen with title in Texas and particularly in the Permian Basin, when there's been so much activity over the past 5 years, are there common things that you guys are seeing come up, or does it default back to pretty much the things that you're always looking for and you kind of always see?
Sure. Yeah. The things that we have found that are a little bit more challenging in Texas, people in Texas are quite savvy in terms of their lease language and what they're drafting up for their leases. And so it's really, really important to carefully analyze all of your leases, all of your assignments, and make sure that the leases are corresponding with the operator's plans. That's, of course, not to say that mineral interest owners are not savvy in other states. I'd say across the board, I'm seeing mineral interest owners become quite educated and very savvy in all states. But in Texas in particular, because they've got this rich history of oil and gas production, they're very aware of their lease rights and what they're entitled to do. And Texas is unique for a number of reasons, but the ability to pool or drill across multiple sections is a little bit different than in other states. And so that requires another level of analysis as to whether or not the operator is able to comply with the lease terms under their drilling plans. So in Texas, they might need to get production sharing agreements or something along those lines if they're planning to drill across multiple sections, or we'll also see terminations in leases based on the particular size of the unit. And it can lead to a whole number of things because unit sizes can change, and it requires an additional analysis of what is permitted under the lease. So I guess the biggest thing that we're really focused on, in addition to the basic foundations of our mineral title and our leasehold title to make sure that's clean, is just really ensuring that our operators are complying with the terms and provisions of the leases with regards to their planned operations.
Sure, I think that makes a lot of sense. And, I don't think there's a Texan out there that didn't smile when you mentioned them being more savvy. But like you said, I think information is becoming more available for everyone and people are educating themselves more.
Yeah, and I think that like you've spoken to a couple of the challenges about the complexity and the just the long history in Texas. But can you tell me a little bit about what's the most complex title opinion you've run into in terms of maybe the number of mineral owners or number of conveyances, and maybe in Texas or maybe some other state? But I mean, because I've heard of anecdotally operators talking about, $1 million title opinions and just the complexity that some drilling spacing units have.
Oh, yeah. I mean, we've probably been guilty of some of those $1 million title opinions, unfortunately. Of course, we're trying to be mindful of the cost, but things can get quite hairy quite quickly. In fact, Texas can get really challenging. We see that the number one thing that makes title tricky is the number of parties involved, of course. So no matter where you are, if the minerals were severed in 1901 and they've gone to 1,000 people, that's going to be a expensive, long, challenging title opinion, especially if each of those interests has something wrong with it, heaven forbid. We can definitely get into the more expensive title opinions there. I think, oh gosh, not to really call out a particular state, but Utah has always thrown some curveballs at me. Just the number of owners that we can see. So I guess by way of background, when an interest varies from another interest, so non-uniform ownership within a section, we designate that as a certain tract. So, a 640 acre section could have a number of different tracts, meaning different people own in the northwest quarter versus the southwest versus the southeast, etc. Some of the opinions that we've run in Utah, we've had 100 tracts, and each tract could have 200 owners. And that's when we'll start getting the 1,000-page opinions. And I'm sure operators love those, but our job is to tell them who owns in that section. And, they can make the determination if they're going to proceed, because if you have 1,000 owners, you have to get 1,000 oil and gas leases or address the owners that they're not able to lease or find. And it can be really challenging from a pay standpoint if they've got 1,000 parties there, but we'll see them do it. And, we're mindful of costs as well, but sometimes they just get really tricky.
Wow, I can imagine being detail oriented both on the title attorney side of things as well as the division order analyst standpoint. It could be very important. And along those lines, what are some of the things that mineral and royalty owners should look for in a title attorney if they need legal help?
Sure. I think the biggest thing is to really just make sure that find an oil and gas mineral attorney that's really all they do, that their practice is focused predominantly in oil and gas. That's number one. That's not to say that, there's fantastic attorneys in every field, but a real estate attorney really just may not have the same level of experience with oil and gas that someone who's been practicing in oil and gas for 25, 30 years is going to have. As you both know, it's a whole nother animal. Interpreting a lease, interpreting some of these documents, there's a lot of knowledge that goes into that. There's a lot of experience necessary in understanding those terms and in knowing the case law that's out there. So first and foremost is finding someone who really does practice predominantly in oil and gas. And then, of course, it's also really important to make sure that that person practices in the state that your minerals are located in. It's important that they have experience in that state because they might understand oil and gas and the concepts, but understanding what's happening in the state where your minerals are located is also really important. So, for example, as Matt said, I'm licensed in Colorado and in Utah, and I will write title opinions for other states as well in conjunction with the licensed attorneys in my firm. But I will not say that I know anything about oil and gas title in Florida. I'm not licensed there. I don't practice there. My firm doesn't practice there. I wouldn't feel comfortable assisting somebody if they had a question about title in Florida. So it's really important that you find someone that's licensed in the state where your minerals are located, and then just chat with them. And if they are able to give you a sense of, yeah, they understand what's going on, they've dealt with something similar, I think that's, the biggest is make sure they're qualified and make sure you get a sense of this person's handled something similar before we can move forward.
That makes sense. Well, fortunately, there's not a lot of oil and gas in Florida. It's a nice place to visit, but so wrapping up, what resources would you recommend for our listeners that want to find out more about the title process and some more about the things that we've talked about today?
Sure. Yeah. I mean, there's great resources out there. A lot of the operators have information on their websites. Your division order analysts are great resources as well. They can help point you to information that might be relevant to your issue or that might be relevant to where the operator is planning to develop. The National Association of Royalty Owners, which I'm sure most of your listeners are familiar with, and the National Division Order Analyst Association are great resources as well. And most of the big plays have some kind of blog or resource out there to start with and just kind of get an understanding of what development looks like, what regulations look like, who are the big players. That's kind of higher level. And then again, your landmen and your title attorneys they're the ones on the ground. They're the ones that are seeing these title issues. I know the thought of hiring somebody or hiring an attorney can always be a little overwhelming, but knowledge is power, and title attorneys are quite versed in seeing certain issues. So, they might be able to look at something and without too much time be able to either provide you with some answers or help you find some direction on steps that you can take to learn more. So I think, start higher level. The internet's such a great resource, but landmen that are out in the field and title attorneys that are looking at the title all the time are great sources of knowledge.
Absolutely. And is there anything else that you'd like to mention that we haven't already covered?
Gosh, I feel like we've talked a lot about a lot of things here. It's an interesting field because it's a lot like a puzzle, putting together these division order opinions. We're figuring out who owns all of this. And it's a lot of really interesting research and trying to figure out how certain states or certain courts would determine an interest. But I think, if I could provide one takeaway for your listeners, for mineral interest owners, it's that this is still, in my opinion, a little bit of wild, wild west. Sometimes I'll rely on cases from 1920 when I'm figuring out how to call an interest. And it is definitely something that can be a little bit variable, and hopefully in understanding the process behind it, your listeners can have a better understanding of why there may be changes or why their interest might look a certain way. And, we're really out here doing the best we can to try and figure this puzzle out for everybody.
Yeah, it is a very complex puzzle, and I definitely appreciate the complexity more now after hearing you describe some of these challenges. I know that it's easy to get into the position of thinking that an operator is just trying to do what's going to be in their best interest, but the complexity involved, they're trying to do what's right and follow the letter of the law. But there's just so many different variables. I can see now how it can go one way versus the other. So thank you for helping us understand that. And where can our listeners go to find out more about your firm, and how can they contact you if they have a question?
Sure. So the firm I work for, again, is called Lear and Lear. It's Lear. And our website is learlaw.com, learlaw.com. And there you can see everybody, all the attorneys' profiles there, all the states that we practice in. We also do a little bit of renewable work. And so you can see some of that there. And then if anybody wants to contact me directly, my email is liana.jones@learlaw.com, spelled LIANA.JONES at Lear Law.
Great. Well, thank you again, Liana. Appreciate your time, and thanks for educating us on the world of title opinions.
Thanks so much for having me today.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.